Let's continue our discussion on property. This time we cover Articles 427 to 439 of the New Civil Code. Ownership in general. Article 427. Ownership may be exercised over things or rights. Ownership is the independent and general right of a person to control a thing, particularly in his possession, enjoyment, disposition, and recovery, subject to no restrictions except those imposed by the state or private persons without prejudice to the provisions of the law. Kinds of ownership. 1. Full ownership or dominium or jus in re propria. This includes all the rights of an owner. 2. Naked ownership or nuda proprietas. This is ownership where the right to the use and the fruits has been denied. 3. Sole ownership, where the ownership is vested in only one person. And 4. Co-ownership or tenancy in common, where the ownership is vested in two or more persons. Article 428. The owner has the right to enjoy and dispose of a thing without other limitations than those established by law. The owner has also a right of action against the holder and possessor of the thing in order to recover it. Under Article 428, an owner has the following rights: the right to enjoy, the right to dispose, and the right to recover or vindicate. The right to enjoy includes the right to possess, the right to use, and the right to the fruits. The right to dispose includes the right to consume or destroy or abuse, and the right to encumber or alienate. Under Roman law, an owner has the following rights: jus possidendi, or the right to possess; jus utendi, the right to use; jus fruendi, the right to the fruits; jus abutendi, the right to consume and also to transform or abuse; jus disponendi, the right to dispose; and jus vindicandi, the right to recover. Hence, if I am the owner of a house, I can live in it, use it, receive rentals from a tenant in case I lease it, destroy it, sell or mortgage or donate or alter it, and recover it from anyone who has deprived me of its rightful possession. Article 429. The owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. This article speaks of the principle of self-help, namely, the right to counter in certain cases force with force. Example: I have a car, I see a thief about to get it. I can use force in driving the thief away, provided that the means I resort to are reasonable. As a matter of fact, I can even chase him immediately and recover the car from him by force. If, however, I lose sight of him and I see him only 2 or 3 days later, I will not be justified in taking the law into my own hands. I will have to resort to the courts of justice in order to recover my car. Article 430. Every owner may enclose or fence his land or tenements by means of walls, ditches, live or dead hedges, or by any other means without detriment to servitudes constituted thereon. Example: a person may fence off his house and lot unless he denies others a right of way to which the latter may be entitled. Article 431. The owner of a thing cannot make use thereof in such manner as to injure the rights of a third person. This is one of the fundamental bases of police power and constitutes a just restriction on the right of ownership. For example, I cannot blow my saxophone in the middle of the night because I would unduly disturb the rights of others to a peaceful sleep. Article 432. The owner of a thing has no right to prohibit the interference of another with the same if the interference is necessary to avert an imminent danger and the threatened damage compared to the damage arising to the owner from the interference is much greater. The owner may demand from the person benefited indemnity for the damage done to him. This article refers to a state of necessity as distinguished from the principle of self-help enunciated in Article 429. Under the revised penal code, the state of necessity is considered a justifying circumstance. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, does not incur criminal liability provided that the following requisites are present. 1. That the evil sought to be avoided actually exists. 2. That the injury feared be greater than that done to avoid it. And 3. That there be no other practical and less harmful means of preventing it. For example, while I am driving an automobile with due care, an animal stands right across my path, rushing towards me. On either side of me is a precipice. I am thus forced to decide whose life I would save, mine or that of the animal. If I kill the animal by driving straight across, the owner of the animal, if he should happen to be nearby, has no right to interfere with the destruction of his animal. Article 433. Actual possession under claim of ownership raises disputable presumption of ownership. The true owner must resort to judicial process for the recovery of the property. The two requirements to raise a disputable presumption of ownership are the following. 1. Actual possession, and 2. Claim of ownership. This article applies both to immovable and movable property. Article 434. In an action to recover, the property must be identified and the plaintiff must rely on the strength of his title and not on the weakness of the defendant's claim. The requisites in an action to recover are the following. 1. Property must be identified. And 2. Reliance on title of the plaintiff and not on the weakness of defendant's title or claim. If the claims of both plaintiff and defendant are weak, judgment must be for the defendant, for the latter, being in possession, is presumed to be the owner and cannot be obliged to show or prove a better title. Based on decided cases, among the evidence which may be presented by the plaintiff to show ownership are the following. 1. Torrent certificate. 2. Titles granted by the Spanish government. 3. Long and actual possession. 4. Occupation of a building for a long time without paying rentals therefore. And 6. Testimony of adverse and exclusive possession of ownership corroborated by tax declaration of properties, payment of taxes, and deeds of mortgage. Article 435. No person shall be deprived of his property except by competent authority and for public use, and always upon payment of just compensation. Should this requirement be not first complied with, the courts shall protect and, in a proper case, restore the owner in his possession. Eminent domain, or the superior right of the state to own certain properties under certain conditions, is a limitation on the right of ownership and may be exercised even over private properties of cities and municipalities, and even over lands registered with a torrent's title. While eminent domain refers to the right, expropriation usually refers to the procedure through which the right is exercised. The essential requisites of eminent domain are the following. 1. Taking by competent authority. 2. Observance of due process of law. 3. Taking for public use. And 4. Payment of just compensation. Based on decided cases, private property may be validly expropriated for the following uses or purposes. 1. Market sites and market stalls. 2. Military and aviation purposes. 3. Roads, streets, public buildings including schoolhouses, cemeteries, and artesian wells. And 4. Land needed by railroad companies for their railroad. Article 436. When any property is condemned or seized by competent authority in the interest of health, safety, or security, the owner thereof shall not be entitled to compensation unless he can show that such condemnation or seizure is unjustified. This article is based on police power, which in turn is based on the maxim that the welfare of the people is the supreme law of the land. Unlike eminent domain, which requires the giving of just compensation, police power needs no giving of the financial return before it can be exercised. This is therefore one instance when property may be seized or condemned by the government without any financial compensation. Police power can refer not merely to condemnation and seizure, but also to total destruction itself, provided that the public interest is served and the means used are not unduly harsh, abusive, or oppressive. A state, in the exercise of police power, may abate nuisances, whether public or private, whether per accidens or per se. Public nuisance is that which affects a community or a considerable number of persons. Private nuisance is that which is not public. Nuisance per se is that which is nuisance under all circumstances, and nuisance per accidens is that which is a nuisance only under certain circumstances, like a factory situated in a residential district. Article 437. The owner of a parcel of land is the owner of its surface and of everything under it, and he can construct thereon any works or make any plantations and excavations which he may deem proper, without detriment to servitudes and subject to special laws and ordinances. He cannot complain of the reasonable requirements of aerial navigation. This article deals with the extent of ownership which a person has over a parcel of land, more specifically with what is commonly referred to as surface right. Thus, if a person owns a piece of land, it is understood that he also owns its surface up to the boundaries of the land, with the right to make thereon allowable constructions, plantings, and excavations subject to, number 1, servitudes or easements, 2, special laws like the mining law, 3. Ordinances, 4. The reasonable requirements of aerial navigation, and 5. Principles on human relations and the prevention of injury to the rights of third persons. Surface right must also be restricted by the reasonable requirements of underground shelters and depots with proper state permission, as long as the surface right is not substantially disturbed. It is further understood that the Regalian doctrine, or the state ownership of mines and natural resources, stressed in the Constitution and implemented in the mining law, must be observed. Hence, mines discovered underneath the land should belong to public dominion inasmuch as they are properties for the development of our national wealth. Article 438. Hidden treasure belongs to the owner of the land, building, or other property on which it is found. Nevertheless, when the discovery is made on the property of another, or of the state or any of its subdivisions, and by chance, one half thereof shall be allowed to the finder. If the finder is a trespasser, he shall not be entitled to any share of the treasure. If the things found be of interest to science or the arts, the state may acquire them at their just price, which shall be divided in conformity with the rule stated above. Hidden treasure may be found on the following: 1. Land, 2. Building, and 3. Or other property. For example, if X finds a hidden treasure in his house, he alone owns the treasure. But if he is married, the treasure belongs to the absolute community or conjugal partnership, whichever is in application. For the finder to be entitled to one half, the discovery on another's property must be by chance. This means, according to Spanish commentators, that there must be no purpose or intent to look for the treasure. Article 439. By treasure is understood, for legal purposes, any hidden and unknown deposit of money, jewelry, or other precious objects, the law for ownership of which does not appear. Requisites in the definition of hidden treasure. 1. Hidden and unknown deposit, such that finding it would indeed be a discovery. 2. Consists of money, jewelry, or other precious objects. And 3. Their lawful ownership does not appear. Following the doctrine of ejus dem generis, the phrase other precious objects should be understood to refer to those of the same class as money or jewelry, and should not therefore include property embedded in the soil or part of the soil like minerals. This is the end of part 3. Thank you.